Buenos días a todos. Qué bueno que nos están acompañando. Vamos a esperar un par de minutos que se termine de registrar en el Zoom y de inmediato empezamos. Pues muy buenos días tengan todos ustedes. En nombre de Bargalló, Cardoso y Asociados, agradezco su presencia y participación en este webinar Doing Business in USA que hemos organizado conjuntamente con nuestra firma asociada en Nueva York, Hoberman Lesser. Como muchos de ustedes saben, Bargalló Cardoso es parte de MGI Worldwide, una red de firmas de contadores con presencia en más de 100 países. Y es por ello, y conociendo el interés que existe en el tema, decidimos ofrecer a ustedes este webinar que sin lugar a dudas les resultará de gran utilidad. También participa en este webinar Michael Einbinder, socio fundador de la firma de abogados Einbinder Dunn, quien nos ofrecerá una visión adicional de aspectos legales a considerar al hacer negocios en Estados Unidos. El webinar es en inglés y al final del evento les enviaremos la presentación y la grabación para su posterior consulta. Sin más preámbulos, permítanme dar a ustedes un resumen del currículum de nuestro primer expositor, Robert Hoberman. Robert se unió a Hoberman Lesser, firma de contadores basada en Nueva York, en 1981. Se convirtió en socio 4 años más tarde y ahora se desempeña como socio director. Cuenta con más de 30 años de experiencia en consultoría de negocios, trabajando con todo tipo de empresas. Su experiencia abarca desde la estructuración de negocios, valuaciones, planificación fiscal y planificación de herencias y donaciones, incluido el uso de fideicomisos. También tiene una amplia experiencia en negociaciones con bancos e instituciones financieras, así como un tremendo conocimiento del procesamiento de datos, análisis de sistemas y consultoría para aplicaciones comerciales. Graduado de la Universidad de Syracuse, Robert es contador público certificado en Nueva York, Nueva Jersey, Connecticut y Florida. Es miembro del Instituto Americano de Contadores Públicos Certificados y de la Sociedad de Contadores Públicos del Estado de Nueva York. Robert es autor regular de artículos que se publican en la revista Rappaport para abordar oportunamente cuestiones fiscales y financieras relacionadas con la industria de la joyería y ha sido un orador destacado en diversos seminarios organizados por la Academia de Abogados Litigantes del Estado de Nueva York. Now, Robert, this is your audience. Go ahead.
Okay, thank you very much, Rafael. I'm going to share my screen right now. And share. Okay, it's all good, Rafael? Everyone can see it?
Yeah.
Yes? Okay, good. Okay, thank you, Rafael, for inviting me and Michael to speak to your clients at this webinar that we hope will be very informative and educational for everybody. I'm the managing partner of Hoberman Lesser, a mid-sized accounting firm located in New York City. We've been in business for 92 years. My grandfather started the firm in 1930. We deal mostly with small business enterprises, foreign entities setting up operations in the US. We do public company work as well. We're a PCAOB registered firm. Forensic accounting, litigation support, estates and trusts, and transfer pricing studies. Let's go. Okay, before I get started, I just want to apologize in advance for any language that is translated poorly. I never mean to offend anyone. but the translation may make embarrassing or offensive errors that are out of my control. I'm going to cover a lot of topics today and will not be able to go into any of them in great detail. However, we'll take questions at the end, and if anybody wants to contact me directly, I'm happy to answer your questions. Since there is limited time, I'm only going to cover a limited amount of areas. So let's get started. Hopefully we'll get this all done in under an hour, get you in and out of here. So doing business in the US, the first choice you have to make is the type of entity you're going to do business as. Most foreign entities choose either corporations or LLCs, and limited liability companies normally are taxed like partnerships, but in the US you can make an election so that your LLC can be taxed like a corporation. Other choices not used as much: partnerships, trusts, S corporations. Those are mostly avoided because typically the foreign investor does not want to file a personal tax return in the US. And the first two choices would allow them to do business without having to file personally. In the US, all entities are formed at the state level. In addition to the legal rights of the shareholders and the corporate obligations, we take into consideration the tax rules in the state of formation and where the entity is going to be doing business. Corporations, foreign entities typically set up a 100% owned subsidiary. It doesn't have to be 100% owned, but that's what typically happens. And then the foreign entity can pay dividends to the shareholders, the foreign owned parent. Ordinary dividends are subject to withholding tax in the US. Liquidating dividends typically are tax-free to the recipient. I just want to make sure I don't miss anything. So income taxes are imposed at the federal and state level, and we have to take into consideration the different rules for both of these factors. And state levels are going to be where you are incorporated and where you do business in with states. For an LLC, if there's only one member, if an LLC only has one member, then it's disregarded for tax purposes, and all of the economic activity happens at the parent's level. So a foreign corporation will usually set up an LLC. It'll own 99% of the entity, and somebody else, it could even be a related entity, owning the 1%, so that the LLC is not disregarded. Or the LLC will make an election to be taxed as a partnership, as a corporation. And that election has to be made within 75 days of the start of the tax year. And the start of the tax year is either the first day of your fiscal year end, or from the first day you were formed, the first day you were incorporated. On a partnership, the income or loss flows through to the owners, and the owners have to file a US federal and state tax returns and pay the tax, whether the cash is distributed or not. Partnerships must withhold tax on distribution to profits up to foreign partners. And those are the two reasons why foreign entities or foreign individuals usually do not do business as partnerships. You can also be the branch of a foreign corporation. A foreign corporation can do business. It's a non-resident entity selling goods and services into the US. If the foreign entity has what's called effectively connected income to the US, and it has a permanent establishment defined as a fixed place of business or employees in the US for more than 180 days. So if it meets those two things, then the foreign company has to file a tax return in the US and pay taxes on its US income. If the effectively connected income is greater than 25% of the foreign corporation's gross income, then the dividends paid to a US non-resident will be subject to withholding. They could also be subject to a branch profits tax of 30% that may be eliminated depending upon the country and the tax treaty. US companies doing business outside the US, I'm going to spend almost no time on this. It's subject to Subpart F income and may have to pay taxes on the income that is not repatriated back to the US. This is a very complicated topic. I could do a webinar on just this one thing, and this is not the right audience, I don't think, for that. But if anybody has questions about the taxation of US entities doing business in Mexico, please feel free to contact me after this webinar is over. Corporations, no matter where a corporation is formed, remember, corporations are formed at the state level. So no matter what state the corporation is formed in, the corporation must file a federal income tax return and at least a state income tax return in the state it's formed. They also have to file for any states that they do business in. Right now, the maximum federal tax rate is 21%. There are current bills in our legislation. It's a very, it's a high priority item for the current administration to raise the corporate tax rate. It could go as high as 28%. Most people seem to think it'll go to 25% if they pass the current legislation. State tax return rates vary by state. They could be from 1% to 12%, or that some states have zero income tax for individuals, like Florida. Some states have a city income tax as well, so they'll have a state income tax and a city. For example, New York City, where I am, has both a federal, state, and city tax. Some states provide certain tax benefits for bringing jobs into that state. That's usually determined on a case-by-case basis. And if it's available, it's usually for economically disadvantaged areas. There are other types of credits available, solar energy, research development, etc. And we can help if you have questions about forming an entity and bringing jobs to the US. We can help you to look for those credits as well. An individual, all US citizens are taxed on their worldwide income no matter where they live. So if you're a US citizen and you're earning income in any other country, Mexico, European Union, no matter where you live, you're taxed on your worldwide income. Green card holders are treated like US citizens. They are also taxed on their worldwide income. A non-resident, non-US citizen must file a tax return in the US for income earned in the US. In the US, unlike several other countries around the world, the US government does not prepare a tax return for you. You need to prepare your own tax return and file it by the due date, usually April 15th. You get extension till October 15th. Non-resident, non-US citizen does not have to file a tax return if the money's earned outside the US, even if it's paid to them by a US entity. So if you're in Mexico, you work for a US company and you work in Mexico, you do not file the US return. And if a non-US citizen must file a tax return US and pay tax, they usually get a credit in their country of citizenship for taxes paid so that you don't get taxed on the same income twice. That's dependent upon tax treaty. The US and Mexico obviously do have tax treaties. The maximum federal rate for an individual is 37%. The current administration is looking to raise that to 39.6%. State income tax returns usually get filed at the same time the federal tax return is done. The state income tax, whether you have to file in a state, is dependent upon where you're domiciled, and I'm going to get into that a little bit later. Where the income is earned, tax rates vary by state for individuals, and some states also have a local personal income tax, like New York City. Not only does it have a local corporate tax, it has a local income tax. So what do foreign entities usually do to insulate themselves from the US tax system, from the IRS? Most foreign entities or foreign individuals both will create what we call a blocker entity. Typically, it's some type of a corporation. It could be an LLC that elects to be taxed as a corporation. It could be a trust. Trusts are a little more complicated to set up. If you do that, you set up a blocker entity for an individual, it could eliminate any estate tax issues and personal income tax issues, but not corporate taxes. And you may, if you set up a US company and you're doing business in the US company may qualify for certain federal or state programs. The domestic production credit is one, energy credits are another. The PPP was another program that's expired. That was a very generous program for employers to continue paying their employees during the pandemic. You can set up a corporation, and then the next thing you need to do is you need to get an employer identification number. That is a unique number given out by the US government to each business entity, trust entity, and for individuals, it's a social security number, it's the equivalent. And why do you need one? Every tax return that's filed needs to have an employer identification number. You won't be able to open a bank account without an employer identification number for the business entity. And how do you get one? There's an easy way and there's a long way. The easy way, if you have a responsible person who has a social security number, it probably takes about 10 minutes to get an employer identification number. If you don't have a responsible person, the responsible person is a term that the federal government uses. It's used in conjunction with the person who's going to be responsible to make sure that tax returns filed. If you don't have a responsible person with a social security number, you have a foreign owner who has no ties to the US, doesn't have a social security number, then you've got to file a W-7 and you have to submit that W-7 with numerous other original documents, not copies, originals, passports and all kinds of things. And depending upon the agent that gets the package, they may or may not ask for more documents. That whole process takes somewhere between 2 to 6 months. So if you don't have a responsible person, you need to do some long-range planning to open up an entity in the US and to open up a bank account. Nexus. So Nexus is the defining terms for when you are effectively connected to a place or an entity. So if a foreign entity has effectively connected income to the US and it has a permanent establishment defined as a fixed place of business. So you rent an office, you have a warehouse, you store goods that are being sold by Amazon at Amazon's warehouse, but they're your goods, then you very well may have a permanent place of business in the US and effectively connected income. You might want to open up a US entity to handle your transactions so that you can keep the parent company off of the IRS's radar. Forming an entity in a state automatically gives you nexus with that state. So if you create a Delaware entity or a Florida entity or a Texas entity, you are automatically have nexus with that state. So nexus at the state level is a different definition than the federal definition. For income tax purposes, nexus at the state level is defined typically as a physical presence. So any one of the 3 examples could give you a nexus with the state. Having inventory in the state, having fixed assets in the state, you have a repair shop or a service center in the state that services the entire country. Having those machinery and equipment in that state gives you nexus. Having an employee in the state, you have a president of a company or a sales manager, that employee sitting either at home or in an office would give you nexus with where they're physically located. For sales tax, nexus is a different concept. A couple of years ago, the Supreme Court, the highest court in the land, came out with what we refer to as the Wayfair decision. And the Wayfair decision said that even without the usual nexus definition, even if you don't have a physical presence in the state, an entity could be subject to collecting sales taxes if it sells or ships a certain amount of sales taxable goods into the state. I'm going to go into this in a little bit more detail a little bit further in the presentation. Transfer pricing. Transfer pricing is the methodology at which one creates the prices between related entities. So transfer pricing, price paid in a transaction between related or controlled parties. The main types of intercompany transactions are tangible goods, intangible property, services, and financing. Loans are a means of intercompany transactions. Most countries require taxpayers to prove that their intercompany transactions are at arm's length. The primary concern of the countries is they want to make sure that income is being recognized fairly at the place it's being earned at. They don't want you to transfer all of the income by artificially creating high prices in one place and low prices for something else. There's no requirement in the law that you create a transfer pricing agreement. This is a topic that gets very complicated. I'm just going to go over the highlights of it. The IRS, the Internal Revenue Service, has the right to impute a transfer pricing strategy if you don't have an agreement. Otherwise, if you do have an agreement, they'd have to prove that your methodology is wrong. Absent an agreement, the IRS doesn't have to prove that you're wrong. You'd have to prove that they're wrong. The potential effects of not having a transfer pricing agreement, you could wind up with a one-sided adjustment. You could wind up with income in the US and not having a deduction in your host country or vice versa, thereby subjecting you to double taxation. You could wind up that interest is not deductible. You could wind up with penalties and interest on an assessment. Penalties would not be deductible. You may wind up with unintended transfers of intangibles. You could wind up with a recharacterization of debt or equity, typically taking debt and transferring it to equity and locking it into the company, making it difficult to get the money back out. Or the mix of losses and profits among the entities may not be the ideal way that you like to see them. They may not be realistic. You could wind up with more income in a high tax environment or less income in a low tax environment. And we help with the transfer pricing studies, and there are two different levels, by the way. There's a transfer pricing light and a full transfer pricing agreement. And again, anybody who wants to know more about it, I'm happy to talk about it in depth later. A question I get asked a lot is, how do I capitalize my new US entity? Do I put money in as equity? Do I put money in as loans? Typically, foreign companies or foreign investors put money into US entities as loans. It's easier to get the money out as a loan than it is to get equity out. There really are, we don't have the same thin capitalization rules that other countries have with minimum required amounts of capital. But in order for it to be a loan, there are certain minimum interest rates. There's a thing that's called the AFR, the applicable federal rate, published by the IRS every month. It's short-term, mid-term, long-term rates. At a minimum, you have to use those rates. You could use more. They have to be commercially reasonable. And you have to document that this is really a loan. You have to sign a loan agreement, and loan agreements call for interest and repayments and have due dates. So you'll need to consult with Michael to get loan agreements drawn up when you put money into your new US entity. Choosing a bank, it is getting more and more difficult to open up a bank account in the US. Even a year ago, it was easier than it is now. The banks have what we refer to as the KYC rules, the Know Your Customer rules. They typically require an entity to have a U.S. address and a U.S. employee. Now, I'm seeing this more and more from more banks that they want to make sure you have an actual place of business in the U.S. and it's not just a mailing address. If you want a line of credit with a U.S. bank, then it's not required. There's no requirement for a U.S. entity to get a financial statement prepared. There's no requirement to have an audit done to do your tax return. However, if you're going to a bank and you want credit, it is typical that a bank will ask for a U.S. prepared financial statement on GAAP basis, which is generally accepted accounting principles. The U.S. uses a slightly different accounting methodology than the rest of the world. Typically, the rest of the world uses IFRS. The U.S. is on GAAP. Or the bank may accept an income tax basis financial statement. They may accept the financial statement on the same basis that you prepare your tax returns. It's difficult for a foreign entity to get a line of credit. It's not impossible. It's beneficial if you have a relationship with the bank outside the US. So if you're a regular banking customer with HSBC, it's easier to get a line of credit. And that has to do with banks that usually look for Plan A and Plan B to get paid back. So Plan A is that they would expect the company to pay them back. And then Plan B would be the guarantor of the loan to pay them back. And it's difficult for a bank to enforce its rights against a non-resident person. Sales taxes. This is one of the big differences between the US and the rest of the world. The US has sales taxes. The rest of the world typically has a value-added tax, a VAT tax. The US does not have a VAT. There is no VAT tax in the US. We only have an income tax, and the sales taxes are at the state level. There is no federal sales tax. So sales tax are a consumption tax levied against the ultimate consumer of a product or service. You go to the store and you buy a dozen widgets. Typically, widgets are subject to sales tax. The rates vary from state to state. Some states, they can be as low as 2.9% in Colorado to 9.5% Tennessee. Sometimes the state and the city have a sales tax, which could be combined. And it's in Seattle, for instance, Seattle, Washington, it's over 10%. And sales taxes are not levied all along the supply chain. That's a VAT tax is, a sales tax is not. Sales taxes are only collected from the ultimate consumer. So if you're making a product that goes into the widget and the widget gets combined with something else and and the only person who pays the sales tax is the person who ultimately buys the widget and consumes it. There's no sales tax along the way. And the sales tax liability starts when ownership of the goods pass. That doesn't have to be the shipping point. It's when title passes, when the actual ownership passes. Here's where it gets complicated. So each state determines what's subject to sales tax and what is exempt. So in New York, as an example of how complicated this is, if you go to a restaurant and you buy a sandwich, a ham sandwich, the ham sandwich is subject to sales tax. If you go to a grocery store and you buy ham, you buy a separate jar of mustard, you buy a loaf of bread, none of those items are subject to sales tax. And that's a New York state thing, and different states have different rules, what is subject to sales tax or what is not. Typically, property subject for resale and intangibles are not subject to sales tax. So if I'm the deli owner and I'm buying ham that I'm going to resell, I don't pay a sales tax on my purchase. the customer pays sales tax when they purchase it. And in New York, the sales tax varies from county to county, and I think we have 62 counties in New York. That's unusual. We have 62 different sales tax rates in New York, depending upon where you actually buy the goods. Most states only have one sales tax that covers the entire state. So New Jersey, Connecticut, Florida all have one sales tax for the entire state. A few years ago, the Supreme Court changed the nexus rules for sales tax. Sales tax, it used to be that if you sold goods into a state and you didn't have nexus with that state, if I shipped a sales taxable product from New York into New Jersey, I did not have to register to collect sales tax or collect the sales tax from my customer in New Jersey. Supreme Court came out with a decision a couple of years ago, we call it the Wayfair decision, that says that yes, if you do sell into New Jersey, and New Jersey can set a threshold that's usually around $100,000, could be as high as $500,000. But if you sell into New Jersey, even though you don't send employees there, you don't have a physical office there, you don't have any goods there, you don't have any property there, just the act of shipping goods into New Jersey could subject you to New Jersey sales tax. This becomes a very complicated thing for US entities as well as foreign companies. So if you're in Mexico and you're shipping goods into the US, you don't have a place of business in the US, you don't have employees in the US, you don't have inventory in the US, everything is located in Mexico, and you ship it into New York, and you ship more than $100,000 in sales, you have a responsibility to collect and remit New York State sales tax on those sales. You'll have to register in the state to collect sales tax. You'll have to fill out the forms. You have to charge the sales tax to your customers. This could lead one day to you having to file income taxes in that state as well. It's not the case right now, but it wouldn't surprise me if one day one of the states goes to court and tries to apply this standard to income taxes as well as sales taxes. I get asked a lot of questions about employment considerations. When is a person classified as an employee or not? The IRS has a 20-part test to see if someone's an employee or independent contractor. It's getting harder to classify someone as an independent contractor. And the reason why employees want to treat people as independent contractors is it's less expensive for the company. They don't have to pay the payroll taxes. They don't have to offer medical insurance. They don't have to give them vacation time or sick leave or disability insurance. So for the company, it's less expensive if someone's an independent contractor. The government wants these independent contractors to be covered by all of these social programs as well as Social Security. So they've been pushing harder and harder to make companies record their independent contractors as employees. There's this 20-part test. It's what we call a preponderance of evidence test. It's not that if you fail any one part or 10 parts that the person is automatically an employee. It's what's called the preponderance of evidence test. And the more that they look like an employee, the greater the chances are that the IRS will treat them as employees. Typically, there are 3 of the 20 that are fatal. If you fail any one of those 3, the person's an employee, according to the IRS. But once you start failing 4, 5, 6 of these questions, then they're going to treat that person as if he or she is an employee. When you have employees, you have to pay Social Security tax. Certain foreign nationals are exempt from Social Security tax if they're transferred to the US temporarily, less than 5 years, provided that they're subject to Social Security tax in their home country. But Social Security taxes are paid 50% by the employee. The employee pays half of the Social Security tax, and the employer pays the other half. All of these other taxes are paid by the employer. Unemployment insurance, both at the federal and state level, disability insurance, workman's comp insurance. Some states have a tax for certain social programs, like paid family leave was just instituted in New York. Companies are required to file payroll tax returns every quarter for their employees. And then at the end of the year, there's a special package that has to go out. Most companies, and I mean most, 99% of all companies in the US use an outside payroll service to do their payroll tax returns for them. Other considerations when you're going to hire someone in the US, how much paid time off would be customary for that person, length of work, length of time they've been in the workforce and their typical function, how long the work week is, whether it's 35 hours or 40 hours. There are certain statutory overtime considerations. Certain kinds of employees, if they work more than 40 hours, automatically get time and a half for overtime. How many sick days, whether you're going to have a union, minimum pay is set up at the state level. So you have to be cognizant. You have to know what the minimum pay per hour is in the state you have employees in. There was an attempt recently to raise the federal minimum wage to $15 an hour. It did not pass. Some states have adopted that already. Some states have not. Tariffs, complicated topic. It could have its own webinar. I'm going to go through this very quickly. Types of tariffs, it could either be a fixed dollar amount or a percentage. Tariffs are usually imposed on imported goods. Not all goods are subject to tariffs. Services usually are not subject to tariffs. Legal services, accounting services, consulting, things like that. Estate tax considerations. This is a question that we get a lot from individuals. Obviously, corporations have no estate tax. So the US has an estate and a gift tax system. They're separate, but they're related and intertwined with each other. Estate and gift transfer taxes vary based on whether you are a US citizen or a non-citizen. So for US citizens right now, the maximum estate tax is 40%. That's the federal tax rate. The states can have another, it could be on top of that, with an exemption for 2021 of 11,700,000. That number started at 10 million a few years ago. It's indexed for inflation. It's scheduled to go down to 5 million in a few years. But right now it's 11,700,000. There was some talk about changing that in the Build Back Better legislation. It seems that both the House and the Senate have dropped that portion of the Build Back Better program. So it doesn't look like we're getting a change in the estate tax rate or the maximum amount for US citizens. For non-citizens, non-US citizen who is domiciled in the US, and domiciled is different than a number of days test. Domicile has to do with your intent to live in a place. So, and I'm going to go into that in a little more detail in a minute or two. So US resident alien domiciles, the maximum estate tax is 40% with an exemption of 11,700,000. So that's a US resident alien domicile. That you're saying that you live here subject to all US rules. A US non-resident alien, you don't file a tax return as a resident, but the government, US government has determined that you're a domicile here, then your maximum rate is 40% with an exemption of 5 million. Non-domiciled in the US, non-resident alien, subject to a 40% estate tax on US assets above a $60,000 exemption. So you don't live in the US, you're not a US citizen, but you have US assets, and I'll get into that list in a moment, you could pay an estate tax, everything above 60,000. So a non-resident alien, you're not a U.S. citizen, you don't live in the U.S., you're considered a U.S. domicile if you reside in the U.S. and intend to stay in the U.S. for the foreseeable future. This gets very complicated. I'm not going to go into it in detail. It has to do with your ties to the U.S. If the U.S. government determines that they think your intent is to live here, even though you don't actually live here, they will treat you as a U.S. domicile, and there's all kinds of bad things that happen to you tax-wise on estate and income taxes if you're deemed to be a domicile. And once you're deemed to be a domicile, the only way to get out of that is to actually move out of the U.S. U.S. cited assets include real estate in the U.S., tangible personal property, stock of a U.S. company. Certain assets that are exempt from U.S. estate tax include securities that generate portfolio interest income. So if it generates like a CD, if it generates interest income, it'd be exempt from U.S. estate tax. Bank accounts not used in a trade or business are exempt from U.S. estate taxes, and insurance proceeds. Again, questions I get asked a lot on U.S. estate taxes. How can a foreigner avoid U.S. estate tax? Owning U.S. situated assets indirectly via a foreign corporation or trust, a blocker company. So you own a company in Mexico that has a U.S. subsidiary, and the U.S. subsidiary owns the U.S. assets, then you don't personally own U.S. assets. However, this could trigger other tax issues such as income tax that would need to be addressed. Does a U.S. citizen have to pay tax on inheritance from a non-resident alien? Somebody in the United States gets an inheritance from a non-resident, someone who doesn't live here, a non-resident alien, not a U.S. citizen. There's no tax for the recipient of the inheritance to pay. However, they do need to file a tax reporting form that says they got the money that's on the federal level. And there are some states that have an inheritance tax as opposed to an estate tax. So depending upon the state that the person lives in, they may have to pay an inheritance tax. Inheritance tax are different than estate taxes. Inheritance tax is a tax on the money you receive. An estate tax is a tax on your net worth when you die. Some examples of transfers that are exempt from U.S. estate tax. So property passing to a decedent's surviving spouse if the spouse is a U.S. citizen or resident alien. So a husband or wife could leave their spouse any amount of money if the surviving spouse is a U.S. citizen or taxed like a U.S. citizen. If the spouse is a non-resident alien, then that doesn't apply. A limited number of countries have estate tax treaties with the U.S. that eliminate certain types of assets situated in the U.S. from the 40% estate taxation. This is a list of the countries. Mexico is not on the list. These are the only countries that have some type of treaty that could eliminate it. It's relatively rare. Tax rules differ if a non-resident alien is making a gift during their life or transferring assets at death. So what's considered a gift or a transfer at death is defined a little bit differently. On one hand, a non-resident alien subject to the gift tax on transfers of U.S. currency, real estate, and tangible property located in the U.S. at the time of the gift. On the other hand, intangible properties such as corporate stock and partnership interests are not subject to gift tax. That's if you do it while you're alive, but they could be taxed as part of the non-resident alien's estate at death. Questions again, can foreigners sell property in the U.S.? U.S. law requires that any non-resident alien who sells U.S. real property is subject to withholding for tax purposes 15% of the gross sales price. That's a withholding tax. It's required by the U.S. Foreign Investment in Real Property Tax Act. It's commonly referred to as Ferptor. When you file an income tax return, if the Ferptor withholding is greater than the income tax, you get a refund. So remember, it's 15% of gross sales tax, whereas in the US, you're taxed on your net gain. So if you bought a property for $1 million and sold it a week later for $1 million, and there's no gain, you would still have a 15% Ferptor withholding, $150,000. You would not get that money back until you filed a tax return showing that there was no gain or loss, and you're entitled to the $150,000 refund. I get a lot of questions on immigration issues. I am not an immigration attorney. You're going to see why I'm not, and how complicated this really is. But there's a few pages of information I'd like to share with you about questions I typically get asked about. There are 185 different types of U.S. visas. They pretty much fall into two categories: a non-immigrant visa for temporary stays, such as tourism, business, family visit, study, work, or transit, and then an immigrant visa for permanent residence in the U.S. The easiest way to get permission to visit the U.S. is to win the green card lottery. That's the most complex answer to your problem. It allows you to come and go whenever you want. The U.S. government awards a certain number of green cards by lottery every year. If you get one, it makes coming to the U.S. much easier. It makes you subject to U.S. taxes, though. To get a visa, the B visa is usually the easiest and the most appropriate one to get. The B visa is for non-immigrants wanting to enter the U.S. temporarily for either business, which would be a B1, or for pleasure or medical treatment, a B2. The B2 is probably the best option for visiting the country. For IT workers, the H-1B program has been the visa of choice that allows you to come to the U.S., study in the U.S., and then get a job in your field of study and stay here for 2-year periods that are extendable. There's also the E visa, which is, there's pretty much 3 different types of E visas. There's a treaty investor in E1, a treaty employee E2, or a treaty specialty occupation worker E3, but that's only for Australians. The E1, you're coming to the US, you're going to set up a new company. 50% of the volume of the company has to be between the US and a designated treaty country. The visa holder has to show that they intend to engage in substantial trade, but not a term not strictly defined. An E2 visa is individual investor comes in, they must demonstrate that the sole purpose for entering the US is to run or develop an enterprise. They don't have to create the enterprise, they have to run or develop it. Additionally, the investor must show a risk of capital to qualify for the investment. The E2 investment allows the foreign investors to obtain a visa to reside in the US with their immediate family. So that's with their spouse and children, to develop or direct a commercial enterprise. The investment used to qualify for an E2 must be in an active and operating business that requires people to work. Therefore, businesses that don't require any employees don't qualify. Passive investments don't qualify. Property, stocks, bonds, those do not qualify as the types of business for an E2 visa. I get questions, can I buy a house or other real property in the US and use that to get an E2 visa? No, the business must be an active business. Passive investments like real estate or investments in the stock market do not qualify. For the E2 visa, there is no stated minimum investment actually in the law. Typical practice is that you have to that you must invest at least $100,000, but the actual amount will depend upon the kind of business that you are going to invest in. There's the EB-5 program as well. The EB-5, there's two different flavors to it. There's the direct and the regional center. Regional center program, you invest in a business through a government-approved organization. Not as popular as the direct program. The direct program, you invest directly into the business. The direct program is faster and easier to achieve. How much do you have to invest? Depends if you're in a targeted area or a non-targeted area. Targeted area, 900,000. Non-targeted area is 1.8 million. The amounts will be adjusted for inflation every few years. The EB-5 visa is referred to as a golden visa. It allows the holder to live, work, pursue education, and retire in the US without having to find an employer. Can you immigrate to the US without a job offer? No, you need, if you're going to come on that type of visa, you have to have a job offer. You can buy a house in the US. And buying property in the US is not the path to a green card. You can buy property, but it's not that buying property will help you get a green card. The H1 and H2 visas are for employment or skilled workforces. H3 also for a particular kind of skill. Okay, thank you, everyone. I hope I gave you enough information to better understand how to do business in the US, cope with the state and income taxes, as well as some immigration issues. I hope I didn't scare anybody off. I appreciate the opportunity. And there was a question and answer at the end. Rafael, back to you.
Gracias, Robert. Vamos ahora a escuchar a Michael Einbinder. Michael Einbinder es miembro fundador de Einbinder Dunn y tiene muchos años de experiencia representando pequeñas y medianas empresas en todas las áreas comerciales. La práctica de Michael involucra tanto la resolución de disputas como el trabajo transaccional. Una parte sustancial de su trabajo está dedicado a la ley de franquicias. Michael está calificado como uno de los mejores abogados de litigios comerciales de 2021 por Super Lawyer. También ha recibido el reconocimiento de sus pares en el campo de las franquicias, destacando la inclusión en la lista de los mejores abogados de América de 2022 para la ley de franquicias y clasificado como uno de los mejores abogados de franquicias en los Estados Unidos por Chambers and Partners en la guía de clasificación de Estados Unidos 2021. Doy la palabra a Michael. Michael, go ahead. This is your audience.
Good morning, everyone. Thank you for the introduction, Raphael. My name, as you heard, is Michael Einbinder. I'm a partner at Einbinder Dunn in New York City. We represent small and medium-sized businesses pretty much in every aspect of their businesses, including doing transactional work, corporate work, helping them set up companies, helping them set up the governance for their companies, documentation needed to establish your entity in the States, loan documentation if you need it for that kind of setup, as well as representing clients in a variety of disputes in the United States. My experience from my career has been both in representing clients in business transactions or business deals or in corporate work, as well as in dispute resolution or litigation. I'm a trial lawyer. I'm also an arbitrator with the American Arbitration Association. I know that we want to go to questions and answers, so I won't stay on too long, and Robert covered a lot of territory that relates to what I do as well. And what I want to talk about first is creating entities. Robert mentioned or discussed a fair amount about how these are set up from a tax perspective, and frankly, we rely on accounting professionals such as Robert to give us information about where companies should be formed and the type of companies that should be formed, whether they're corporations or limited liability companies. Robert mentioned in his presentation that he does few partnership or joint venture agreements. I would say that I haven't seen a real partnership agreement or joint venture agreement in a while, although people tend to use that terminology fairly frequently, even though the entity that they're setting up is either a corporation or an LLC. Whatever entity it is, it's formed at a state level. The rules, regulations, and formation requirements may be different from state to state. Some places it's easier to set up a company than in other places. The tax questions aside, where you set up your entity may depend on a number of factors that relate to the way you're going to do business. Limited liability companies give owners a fairly flexible arrangement to set up their distributions and internal transactions that corporations are less flexible on. So we frequently recommend the formation of limited liability companies. The other question is where you set up, and then that question is really dependent on what your goals are. Some states, for example, Delaware, have minimal minority rights protections, and so sometimes companies set up where they intend to have, say, an 80% owner of the entity and a 20% party who's going to invest some money, but is not going to have much of a say in the operation of the business. Well, Delaware is a good place to set up for that because the control that a majority owner exercises over the entity is much more substantial than in other states. So we recommend Delaware frequently. Other issues may prevail that require you to set up in a particular state. You may want to keep the information concerning your shareholders or members of your LLC private. Some states are better for that than others, and the information is not required to be filed in quite a number of states about the ownership structure of the business. So it depends on what you really want to do when you set up your business. Whatever you do, we speak to clients about the governance of their businesses, shareholder agreements or operating agreements, depending on whether or not you're a corporation or a limited liability company. Corporations do bylaws. These are the documents by which you govern and operate your entity on an internal basis. They set up the rules for shareholders or owners to make decisions. They set up the rules for termination of ownership interests and buybacks if necessary. They set a whole variety of structural issues as well as the corporate as well as the distributions of profits and income from the business. But operating companies, again, can be very flexible in how you arrange your internal workings. So the piece of information that I like to give clients, and I've seen it go badly so many times, is that you have to follow your rules. And as a lawyer, as well as an arbitrator, I've seen a number of instances in which the owners of businesses have set a structure for their business and a set of rules on which they're going to operate, but never look at those documents when they take action. So, for example, I represented a client recently, or was an arbitrator in a case recently where a corporation required a shareholder to be terminated and then required a buyback of his shares, but didn't do it in accordance with the rules that the corporation had set up. And as a result, there was a substantial judgment against the majority shareholders for taking improper undue action against their minority shareholder interest. So be careful about the way you operate. Some companies set up, Robert was talking about this before also, you can set up a new entity when you're operating in the US. My recommendation is that you do so. It creates a lot more flexibility for you. It also addresses a number of the tax issues that Robert mentioned. So we typically see foreign entities set up either 100% owned subsidiary or a majority owned subsidiary that is substantially owned by the corporate entity in, say, Mexico. And if you need to have another partner or member of the entity, or shareholder of the entity, you can do that with an internal shareholder. Someone involved in the formation of the business can be your other shareholder. We would set up, and it would be important to set up, again, the corporate governance kinds of information and documentation that we talked about before, so that you have rules and regulations, and whoever looks at this will know that you're following those rules, so that you're actually operating a company with more than one shareholder or member. There are different types of businesses. This is a fairly complicated area that require that are regulated by the federal government. And some of the kinds of businesses are mentioned here. They include national security and defense businesses, nuclear power industry, the maritime industries are very heavily regulated, as are airlines, media and communications, and banking. And so what you have to do on a federal level, at least, is check the federal regulations about this. But what you should also understand, because of the way the government structure is set up in the US, you have to be compliant with state laws and regulations too. So, some states, for example, California and New York, may be more restrictive in how you establish your businesses and what kind of regulations you have to follow. For example, in the products liability area, I can assure you that California has a much tougher regime with respect to products liability issues than other states have here, and you'd be well advised to consider the state that you're forming in, depending on the business that you're going to be involved in, what regulations you have to follow. We can help with all of that when you make a decision about coming to the US, and also make some decisions about what kind of business is going to be operated here. Each place where you set up shop, well, if you form a corporation, say in New York, you don't have to file a separate document for authorization to do business in New York. But if you set up a Delaware corporation, because of the rules that I mentioned before about the way Delaware corporations are governed by law, and you operate in New York, which you can do, you're going to have to file certificates or authorizations to do business in the state of New York. That depends in part on the type of business you're operating and where you're operating, but you have to determine whether or not where you set up your entity is whether or not you're going to be operating in another state, and then make some decisions about the authorizations required in those states that you're going to operate in. And you can actually set up shop in New York, set up your corporation in Delaware, but be operating in any number of states where you'll have to file for authorization to do business if you carry on substantial business in those states. Needless to say, with respect to real estate, there are a lot of local laws that deal with real estate related issues. New York has a very heavily developed real estate laws that govern a number of issues regarding real estate entities and leases. And again, you'd be well advised to review those requirements when you decide where you want to set up your operations. I'm going to speak briefly about labor laws and some of the issues that Robert raised before. There are, of course, federal regulations concerning, or federal laws concerning personnel and how personnel are treated and what you can do in terms of hiring, firing, and addressing things like union and labor activities. So one thing that you should know about is the National Labor Relations Act, which deals with union activities. If you expect to set up, say, a factory here that's already in a business that's typically unionized, you can expect to potentially down the line have some union activity, and you should understand the rules and regulations that go with that. There are also regulations concerning non-discrimination, which include Title VII, which is mentioned at the bottom of this slide. Title VII relates to not discriminating or prohibits discrimination in workplace activities for gender, race, and so on. And so you have to be careful about how your business operates in those arenas. And then the ADA, or Americans with Disabilities Act, and similar state laws govern accommodations that are necessary to provide to people who are disabled. And again, that's something that you should be familiar with. And if you're setting up a physical location or retail or a hospitality business, you have to be very concerned about ADA and state law requirements concerning disabled people. And you have to understand what kind of modifications to your physical space have to be made in order to make spaces compliant with leased space or own space, compliant with ADA or state law disabilities acts. I'm going to spend less time on immigration than Robert did. Just to be clear about it, we don't do any immigration law here at all. Robert covered a lot of the terrain that I would cover in this area. I would tell you that it's critically important to follow the rules concerning immigration issues. We work with firms that specialize in that area, and we can give you a referral for, or work with counsel to help you and set up your work visas, green card holders, and so on. And so information about that is available, but it's not something that we spend a lot of time doing. what I have found out from representing clients from outside of the States is that our rules and regulations concerning employment are somewhat different than in other states, in other countries. First of all, employment agreements are not at all the norm. They are the norm for higher level executives, and they're certainly recommended to be clear about the terms of the employment, the length of employment, compensation, and so on, as well as issues concerning termination of employment if that becomes a problem down the line. Again, you need to follow the dictates of the agreements you sign. I've been involved in a number of cases where companies have not followed their own rules concerning employment agreements that they've actually created. We represent a number of clients in non-compete and trade secret issues, and it's critical for companies to be aware of protecting their trade secrets and then pursuing claims against people who are violating confidentiality agreements, which a lot of employers are required to sign and should sign if they're getting complex commercial information that you don't want shared with third parties. The states, most states, all states in this country are employment at will states, meaning that you can terminate employment for any reason or no reason at all, as long as it's not a discriminatory reason. And so you can hire and fire anytime you want to. That isn't to say that there aren't claims made by employees whose employment are terminated. I would strongly suggest that people set up a set of rules that govern how you deal with your employees, how you manuals for employees to follow documentation concerning employee issues. If there's an employee that you're considering terminating, you should absolutely keep record of any reasons for that, notwithstanding the fact that people can be terminated at will, that is any time. If you're planning on terminating someone because of some aspect of the way they're conducting their job, then it would be a good idea to keep track of and record of issues associated with the problems that you see. As I mentioned before, many companies have confidentiality agreements for employees that have access to trade secret information, and trade secrets are generally governed by trade secret agreements, but there are also state laws that apply, as well as a new federal Trade Secret Act, and you might want to become familiar with that and make sure that the agreements that you have people sign cover the territory or the information and documentation that's necessary to protect that kind of confidential information. We have quite a bit of complex law about post-employment non-competition agreements. There's a lot of case law, a lot of legislative issues about these kinds of agreements. In general, most states, the courts in most states will enforce a non-compete agreement that prohibits someone from going to work for a competitive company after the termination of their employment. What the courts tend to look at is the scope of the non-compete, meaning that, for example, if you're in I have a client who is involved in an insulation business, which has some interesting technology to it, and they have hired someone away from another company who is in the similar business, and we've been fighting about whether or not the scope of the agreement that prohibited my client from going to work for another company in the same industry was too broad. If it's too broad, courts will not enforce it. So you have to be fairly clear in your documentation about what it is you want to, what activities you want to prohibit. And you have to do it within a circumscribed geographical area. So you can't generally have a non-compete that covers the entire United States. Generally speaking, they're limited to miles around. And if it's a national business, you can actually do it on a broader basis. But again, it's going to be looked at very carefully by courts if it has too broad a geographical basis. One of the best ways to look at these issues is to determine whether or not there's a legitimate business purpose in setting up the non-compete, whether there's really something that you need to protect. whether or not that person who leaves your employ will damage your business if they go to work for a competitor. So one of the ways that we address this issue is by making fairly detailed recitations in agreements that we prepare that have non-competes that explain the nature of the business, the reason why it's important for the employee to maintain both confidentiality and to not go work for someone else in the same business after the end of their employment with our client company. So if you cover the legitimate business purpose in the agreement, you can often quote that to the courts if there's a fight about it, and it really typically is very good proof that your non-compete provision in your agreement is or should be enforced. California is like a different country. Non-competes in an employment arena are not enforceable in the state of California. There's a couple of other places where they're more difficult to enforce, but in California, they're virtually impossible to enforce. And so if you plan on setting up business and you plan on having employees bound by non-competition agreements, be careful about California. Again, I indicated before that employers can terminate employees with or without cause. The other thing I would let you know about is that there's legislation in the United States called the Warner Act, which prohibits what are referred to as plant closings or business closings, where I think it's more than 60 employees are going to be terminated. You have to give a certain number of months notice before you close your business and terminate employment of more than X number of employees. So you have to be careful about that as well. The next topic I want to talk about a little bit is intellectual property. This covers copyrights, trademarks, patents, and domain names. The ones that we deal with more often than not in this arena are trademarks, mostly trademarks, but sometimes copyrighted material. This is an area where you have to protect your intellectual property or lose the right to do so. So if you find out that someone's doing business using a name similar to yours, you have to do something about it. Otherwise, you won't be able to do something about it the next time it happens. Similarly, in order to protect a trademark, it's important to register that trademark with the United States Patent and Trademark Office. You can also register copyrights in the United States as well. Trademarks, again, more of our practice, are fairly easy to file for. There are certain requirements relating to it, and the more unusual the name, the more likely you are to get trademark protections. For example, I have a client who created a restaurant called New York Bistro. It has a geographical area, and bistro is simply a restaurant. And trying to get a copyright, or rather a trademark for a name that is generic, will be very difficult. Whereas trying to get a name for something that's unusual will be a more likely trademark application success. I mentioned trade secrets and Federal Trade Secret Act a few minutes ago. Again, you have to be aware of those rules and regulations and be careful to follow them and make sure that your agreements cover federal trade secret protection areas. With trademarks, as I mentioned a moment ago, you also have to protect those trademarks by pursuing cases against people who are using, or companies that are using your trademarks improperly. There is legislation in the U.S. The U.S. Trademark Acts under the Lanham Act allows for recovery of damages as well as injunctions to stop people from using your trademarks if they're using them improperly, or if they're using them and they're similar to yours.
Michael, I apologize to break in on you. I just want to, tell you that I went way over the time that was allotted to me, and we're running over time here. So if you...
Yeah, I'm about to end. I just wanted to mention a couple of things if I could. One of the things that we do a lot of is representing clients in the franchise field. We represent what I refer to as incoming franchisors, that is companies that have a business in Canada, Mexico, Europe, wherever it is, and they're a franchise company there, and they want to set up a franchise business in the U.S. we can work with clients to establish a franchise presence here. There are a number of regulations concerning trademark issues, and I can go over that with anybody. Any of these issues, by the way, I can go over with anybody if they're interested. But franchising is a significant part of our practice. There are registration requirements, disclosure requirements. Structure of businesses, as indicated here, includes setting up different operating entities or different entities to operate the business, including ownership of IP, that is intellectual property, a franchise entity, and others. And we can go over that if that's something you want to do. We also work on licensing deals. I am going to call it a day here. I think we have gone over a bit. We're available to speak to you anytime. You have my email address on this card, and I'm happy to have a conversation with any of you about any issue that you need help on here in the States. And whether it's in New York or in another state, we can either do the work or find someone to work with to help us do the work. So thank you for your time today.
Thank you, Michael. Now we are going to have a brief session of question and answers. There are some questions already in the platform. One of them, before giving you the word, Robert, is like someone is asking if your firm and Michael's firm can help in other states like Texas and Florida. So I guess my answer is yes, and also remember that MGI as an organization, we also have firms that can help you in any of those states. So feel free to call me and I'll give you the information of those firms. So go ahead, Robert, with the questions.
Want me to answer that one or the questions in general?
Everything. You are the expert.
Okay.
You and Michael are the experts.
So as far as servicing clients in Florida, Texas, California, it doesn't matter to us what state you're located in. Our practice encompasses businesses located in all 50 states. So we're ready, willing, able to prepare tax returns and render financial advice, no matter where in the US you're located. Michael, I don't know if you're licensed in Florida or Texas. Michael, your microphone's off, Michael.
Like you, we represent clients throughout the US. We consider ourselves a nationwide firm. There are some issues that are very, very local that we get help on, real estate issues and some employment issues that if we need help, we can get it. We have a lot of attorneys that we deal with throughout the country when we need help. I have, as a litigation lawyer, trial lawyer, I've tried cases all over the country, and usually if not, I need some local help, I can get it, and I can get admitted to practice in those states. So we're really available to do your work on a national basis if you need our help.
Okay. Then the other question, someone asked about transfer pricing studies, whether it can be a non-US firm that does the transfer pricing study. Absolutely. There's no requirement at all that a transfer pricing study is done by a US firm. Another question came up for a foreign entity. If a foreign entity is the owner of a US corp or an LLC, I'm assuming the LLC has elected to be taxed like a corporation, does Ferptor withholding apply? No, it doesn't. If a US company sells real estate, there's no Ferptor withholding. So that is one of the ways around the Ferptor withholding, but then that US company has to file an income tax return reporting the sale of the property. The other two are in Spanish. And Raphael, if you could translate it for me, that would be helpful.
Yeah, it's about the transfer price. So it's about the same. So he's asking like if there is a need of having a US firm performing the transfer price study, but you already answered that.
Okay. And I think those are the only questions that were posed.
Well, I sent you yesterday, Robert. I have some brief conversation with some clients, and they are like kind of shy of answer or asking directly. So could you please include that questions?
Sure. Okay, so for the shy people, let me bring that up on my screen. For the shy people out in the audience, There's a question talking about transfer pricing, a recharacterization of debt to equity. Are there any limit in percentage of leverage for companies, thin capitalization rules, or how the recharacterization works? No, the US doesn't have those types of rules and regulations. You want to establish an agreement. If it's going to be money for equity, there would be a shareholders agreement outlining the terms and scope of the money put in for equity. If it's going to be a loan, there'll be some type of legal debt instrument. And it's important that you hire a lawyer to draft the documents to differentiate the two. Second, property purchased for resale is not subject to sales tax. Does that mean if an individual or an entity purchases a space in a building to use as offices, that purchase will be subject to sales tax? Typically, real estate is not subject to sales tax. I don't know of one jurisdiction where it does. There may be other taxes on real estate sales. There could be a transfer tax or a mortgage recording tax, but sales taxes are not imposed on real estate transactions. If a Mexican citizen owns stock in a US corporation, let's say Apple, for instance, and that stock is held in a Mexican brokerage account, is it still subject to estate tax when the Mexican citizen dies? And how the IRS will know that happened? So ignorance of the law is never an excuse for complying with the law. You can't say you didn't know. You can't ask the question, if I walk down the street and I hit somebody over the head and I don't get caught, is that illegal? It's still illegal if you hit somebody over the head. There are ways, US companies, particularly public companies, have what they call registered agents. Every stock transaction is registered. And there are records as to who bought it and where the stock is being held. Those are requirements for public companies. So there are ways that the US government could pick this up. Dividends are mailed out and paid to people. They could track dividends. They could track the stock register. So yes, if a Mexican citizen owns stock in an American company, that could be subject to estate tax, depending upon how much. If a foreign corporation owns real estate in the US, as an apartment, for instance, is there any withholding tax when that apartment is sold? So if the foreign corporation owns the property, when the apartment is sold, there'll be a Ferptor tax withholding. If the foreign corporation owns a US corporation and the US corporation owns the apartment and it's sold, then there's no Ferptor withholding. Michael, these are for you.
I have that. Okay. Mike, the questions passed to me were, once you have created a corporation or any kind of entity, and after some time you need to invest more money, is there best advice to increase contributions to capital stock? How is it legally structured? Since in Mexico, it's normally a shareholders meeting that agree to issue new shares. I would like to know how, which is the procedure in the US. So there's two answers to that question. First of all, you can set up your entities and governing documents to provide that the company can make a capital call, that is to raise more money from your shareholders or members. That's something you can include in the agreement from the time that you form the entity. And I recommend doing that for a number of reasons, because there's no confusion about whether or not you can do it. And there's also the possibility that, say there are three shareholders and two want to invest more money and one doesn't. The agreement can govern how that works. The 1/3 shareholder may not have to invest, but their interests can be diluted as a result of that. All of that can get taken care of in the agreements beforehand. And secondly, the other way to do it is to do what you suggested in this question, which is to hold a shareholders meeting and come to an agreement with your partners, co-shareholders, about whether or not additional capital can be raised by them. But again, best advice for this is generally to put it in your agreement from the start.
Right. I would just add to that it's generally in the US, it's easier to add money to a corporation by a loan than it is by equity. It's easier to add it and it's easier to get it out.
well, it's easier to document. The loans get paid off before the shareholders receive back their equity investment. So if there's a dissolution or termination of the company or liquidation of the company. So I agree with Robert about that. The next question that's posed to me is it allowed to fire employees just by saying there is no more need for your help? Could you please elaborate which are the justified cases to let employees go without paying severance or other remuneration? So putting aside issues concerning unions and other or employment agreements where you have an agreement to pay severance, there's no requirement to pay severance to most employees in most jobs. There are ERISA issues, which is a federal regulation, which I am not that familiar with, and I can get more advice on that may cover that. But I can tell you, you can fire anyone, as I said before, for no reason or any reason, as long as it's not a discriminatory reason. And that is Title VII, what I mentioned before, which is a law that prohibits discrimination in employment on the basis of gender and race, a number of other provisions that cover that kind of conduct. But again, I strongly suggest to anyone that's setting up a business here and having employees is they really need to keep track of, they need to have regulations, rules about how their employees will operate. They need to document concerns about how their employees conduct themselves in the job. And it's always better to keep a record and say, we fired this person for this reason. You protect yourself a little bit more in that instance, but the law allows you to fire people for any reason in most cases. If you have a business in the US and a client, also a US company, refuses or delays payment of invoices, how easy is it to get your money collected and which are the procedures to do so? Well, I mean, most companies start with demand letters or demand letters from lawyers if it gets to the stage where they can't work it out themselves simply by sending a letter that threatens a lawsuit. But most of the time, collection of obligations is done through lawsuits. It can be time consuming and expensive. It's not really worth pursuing small amounts of money that way. But we represent, other lawyers represent clients all the time who are seeking recovery of obligations that are due to them. If you have a security interest or that is a lien on some of the assets of the company that secures the debt to you, similar to the way a mortgage would secure the debt on a home loan, you can conduct, in some states, directly conduct without going to court, a sale of those assets that are securing a loan, and that can be done relatively quickly. In New York, it can be done, but it's a little bit more complicated. So again, that's going to be a state-by-state issue, but there are collection lawsuits, there are sale of assets that secure loans, secure debts of all kinds. One of the ways to protect yourself is to get personal guarantees from the owners of companies you do business with, because they're more likely to pay it if they have a personal obligation on the line.
Okay, then there's a couple more questions floated in on the chat. Someone asked if assets inherited by a U.S. citizen are outside the U.S., is there an inheritance tax therein? Yes, U.S. citizens are taxed on their worldwide assets and their worldwide income. Doesn't matter where it is. If you're a U.S. citizen, you can pay an inheritance, an estate tax, or an income tax. Then again, can a U.S. corporation be a blocker to avoid a foreigner paying the Ferptor tax when selling? Yes. And that's a fairly common structure, that a foreign individual or a foreign entity, more so a foreign entity, a foreign individual would set up a foreign entity. That foreign entity would own a subsidiary in the US, and the US subsidiary would own the real estate. And then you would have a US entity owning the real estate, not subject to the Ferptor tax. There is a question here that's fairly detailed about immigration and how much I have to invest and how many employees. I'm going to defer on that question. And if that person wants to contact me directly, I'd be happy, or Michael would be more than happy to put them in contact with an immigration attorney.
Okay. Michael, Robert, thank you again for helping us with this webinar. I think it was very, very important for us and all of our clients and friends. And I'm sure like many of them will contact later and maybe ask for some additional help. Thank you again, and thank you for all the participants and attendees. And muchas gracias a todos por participar. Damos por concluido este webinar y agradecemos nuevamente su presencia y su paciencia por haber tardado un poco más de lo comprometido. Gracias.
Thank you, everybody.